Well, good evening, ladies and gentlemen, and welcome to King's College London, and welcome to the 2015 Praelium. Before we let the speakers start, I just wanted to give a few very short welcoming remarks. And first of all, I would like to thank the three institutions that are behind this event. You'll see them up there. Is the Columbia Center for International Commercial and Investment Arbitration, led by the director, Professor George Bermann, who's sitting on the Tribunal. We have three crowns. The International International Arbitration firm, specialists with offices in London, Paris, and Washington, D.C., who have, particularly through Gaetan Verhosel, one of its partners, and to my left, have been instrumental in putting together the event. They've also kindly sponsoring the reception afterwards in Somerset House. And thirdly, King's College London, the Dickson Poon School of Law, to which I'm a member. I have to thank its dean, Professor David Caron, who unfortunately can't be here tonight, but he has been, again, very supportive and instrumental in putting the event together. Let me also thank the speakers, the two advocates, Donovan, my far right, the co-head of the International Disputes Group at the Bermann in New York, and Toby Landau, QC, arbitrator and barrister, member of Essex Court Chambers, and a visiting professor here at King's College London. And the three members of the tribunal, chairing is Teresa Cheng, senior counsel, member of the DCD chamber in Hong Kong, who is a graduate of King's College London and also recently been awarded the fellowship of King's College London. Professor George Bermann, to her right, as I said, director of the Center at Columbia, Jean Monnet Professor of Law at Columbia, and thirdly, Lord Phillips, who is former president of the Supreme Court of the United Kingdom and currently a distinguished Dickson Poon professor here at King's College London. And so I just wanted to warmly thank all the five speakers for agreeing to be here with us and accepting our invitation to launch this inaugural event, the Praelium. I know some of them have traveled far and it's really appreciated. And now, let me just turn to Gaetan Verhosel, my co-convener tonight, who will say something about the event itself.
Thank you very much, Federico, and thank you to King's for graciously hosting the event. And good evening to all of you. Some of you may wonder why we chose the obscure Latin term Praelium as a name for this new event. In part, we did that, of course, because we wanted you to wonder. But we also chose it because of what it means. And Praelium means trial of strength. And we thought it captured actually rather well the idea of having two of the most accomplished advocates in our field deploying their oratorical skills to defend two opposite sides of a legal argument. Because it's the oratorical skills that the Praelium that we've convened today is all about. It's about the art of rhetoric, it's the art of advocacy, it's the art of persuasion. And so while we're confident that you will leave this auditorium tonight feeling enlightened on the substance of this year's theme, which is mass claims and investment treaty arbitration, we also see that almost as a collateral benefit of the real treat, which is to see how two experienced advocates approach the development and delivery of legal argument. As Federico has already said, we're extremely proud and grateful to start this new event with as fine a cast as the one that you see on the stage. And for their benefit, I'll say, what probably goes without saying, but none of the views any of them expresses tonight necessarily reflects any of their personal views. Remember, tonight is about the argument. So with that, and without further ado, I would like to give the floor to the president of this year's Praelium Tribunal, Teresa Cheng. Thank you.
Good evening, everyone. We will now go into the actual moot stage now. This is the exit arbitration, and this is the hearing relating to the jurisdictional objections. And I see the claimant and the respondent here, and I believe the parties have agreed on the order of speeches that is going to be taken place. And I understand that, Mr. Landau, you're going to start in the jurisdictional objections matter.
Thank you very much. Just for clarity, we've agreed that I will have 25 minutes, and then my learned friend will have 20 minutes, and then we'll have replies, and there will be no physical contact between counsel in the course of it.
Very glad.
Just by way of introduction, I appear for the respondent, the Argentine Republic. My learned friend, Mr. Donovan, appears for the claimants, that is Mr. Giuseppe Rossi, and 1,070 other separate entities. I hope, given the limited time, I will be forgiven if I do not introduce each of his clients. The application is the respondent's application for the determination of a preliminary objection that this tribunal has no jurisdiction to hear this claim as it is currently framed. By way of outline, I intend, with the tribunal's permission, to proceed in 3 stages. Firstly, I'm going to very briefly summarize the facts and the background to the preliminary objection. You have had copious written memorials. All of this will be familiar. This will be brief. Secondly, a brief review of the existing authority on the issues that are before you. And then lastly, the respondent's submissions as to the absence of consent. Let me turn then, please, to the first of those 3. A brief summary of the background facts. Between 1991 and 2001, the claimants, Giuseppe Rossi and 1,070 other Italian nationals, purchased on the international markets, various Argentine sovereign bonds. Following the financial and economic crisis of the late 1990s, early 2000s, on the 23rd of December 2001, it's common ground that Argentina defaulted by publicly announcing the deferral of over $100 billion of external bond debt. 2005, Argentina undertook a restructuring of that bond debt. It offered to exchange existing Argentine debt instruments, including bonds, for new instruments valued at around 35% of the value of the original. My learned friend's clients, the 1,071 claimants, did not participate. They were unsatisfied with the terms and conditions of the restructuring offered by Argentina, and they jointly initiated this exit arbitration against my client, the Argentine Republic. And they allege expropriation of their investments without compensation, a lack of fair and equitable treatment, in breach of the Argentine-Italy bilateral investment treaty of 1990, which we will refer to as the BIT. The preliminary objection and the key issue is whether the respondent has consented to arbitrate a collective of 1,071 claims by way of a single reference to arbitration under this BIT pursuant to the Exit Convention. Can I then turn to the second main topic, which is the existing authority on this particular issue. The issue is novel. Until recently, it was without any particular precedent or indeed consideration in the context of ICSID. And in recent years, we now have three key decisions which have been the focus of both sides' submissions, and that is Arbitration against the Argentine Republic 2011, Ambiente against the Argentine Republic 2013, and more recently the Alimony and Argentine Republic case of last year. Each case arose out of the same underlying facts: a collective of Italian investors invested in Argentinian bonds who had rejected the restructuring, and then they had come together collectively to bring proceedings before the tribunal, before an exit tribunal. Just by way of very brief outline, Arbitration involved initially 180,285 individual natural and juridical persons. That later was substantially reduced to about 60,000, and the majority in that case held that there was nothing in the BIT or indeed the Exit Convention to exclude a claim of that type. In Ambiente, the total was 90 Italian bondholders, and again by a majority jurisdiction was accepted. And lastly, in Alimony, there were 74 Italian bondholders. The tribunal proceeded on a different basis to the previous two decisions and held in principle that there could be jurisdiction, but then, for counsel rather annoyingly, if it may be said with respect, parked the key issue by joining the jurisdiction issue to the merits without giving, one may say, entirely definitive guidance as to how they might proceed. Before I leave the existing authority, there are 2 points which needn't be stressed, but I will indeed stress them in any event. Firstly, to remind the tribunal that in this area, of course, there is no strict doctrine of precedent, and so you're not bound to follow the previous decisions. You may find them interesting insofar as you are persuaded by the reasoning, but you're not compelled to follow them. And secondly, to emphasize that of the 3 recent decisions, 2, that is Arbitration and Ambiente, have been accompanied by closely reasoned and very powerful dissents, which I would suggest, in my respectful submission, may well be a source to question the actual precedential value of the majority reasoning. Mr. Tribunal, if I can then turn to the substance of the submission, and that is the respondent's case on the point at hand.
Could I just ask a question? You said that the issue is there consent to a collective arbitration?
Yes.
Does there have to be consent to a collective arbitration, or could that not be a procedural question if is there plainly consent to all the individual arbitrations?
There has to be, in my submission, there has to be consent to a collectivity of separate disputes being brought together in one request for arbitration. And so notwithstanding that there may be jurisdiction for each individual dispute, it is my submission that there has to be consent for more than one separate and analytically distinct dispute to be brought before one single tribunal. And in the course of my submissions, I will endeavour to make that good as to why it is a very different situation to have a collectivity of separate disputes before one tribunal as opposed to one dispute. The respondent's position is that as a matter of both principle and policy, there should be no finding here that Argentina has indeed consented to a proceeding of this structure. And there are 3 points which I'm just going to identify for the tribunal's note, and then I will elaborate on them one by one. Firstly, the nature of the grouping of claimants here, properly analysed, this is an aggregate of separate disputes. It is not a single dispute. We are dealing with separate investors, with separate investments, and separate legal disputes, as defined in the governing BIT, and separate claims for separate relief. And indeed, separate acceptances of Argentina's standing offer to arbitrate. The second point, with that in mind, it is my submission that the scope of consent set out in Article 8 of the BIT does not extend to that configuration. Indeed, there are express words, clear wording, a clear indication that the consent that is in the BIT doesn't extend that far. Indeed, the BIT is inconsistent with this scenario. And lastly, even if I am wrong on that, and even if it could be said that the express words of the BIT could be read in more than one way, there are compelling reasons to come to the same conclusion that this treaty ought not to be interpreted in such a way as to allow this kind of configuration of claims. Can I then turn to each of those 3 submissions one by one? Firstly, the actual nature of the collectivity here. It is, of course, a critical first step in the analysis, to understand what is the nature of the claim that's being brought purportedly within the BIT. And this was the first stage of the analysis in each of the three previous decisions that I've identified. If one's going to test the existence and scope of consent, one obviously has to be clear as to what the consent is said to cover. In Abaclat, the tribunal identified two main categories of collective proceedings. On the one hand, so-called representative proceedings, which would be akin to US-style class actions, where you have a multiplicity of claims in one single action. Indeed, you have one claim, and you have representative relief being sought, which is one kind of relief. And distinct to that, you have aggregate proceedings. That is, separate claims that are aggregated judicially for reasons of case management, but they maintain their separate individual identity. And that would be, for example, the English group litigation order. In Abaclat, the tribunal came up with a hybrid analysis, so-called, that the claims there, they said, were perhaps partly representative and partly aggregate. And that is a conclusion that has engendered much criticism. In truth, in my submission, both there and here, the tribunal is faced with no more than a single aggregation of separate claims and separate disputes. There is no representative nature here in terms of either claims or relief. There's no third-party representative. There's no assignment of each debt to a third party. Rather, each individual claimant is purporting in its own right to accept the respondent's standing offer in the BIT. And as such, each individual claimant in its own right has got to satisfy each of the requirements of the BIT. It's got to demonstrate it is an investor, that it has an investment in accordance with the law of Argentina, it has a legal dispute as defined, that it has served timely notice of the dispute, etc. And of course, each claimant is in a position where it could have brought a claim, an arbitration by itself, separately, under the BIT. If it's going to qualify for each of these separate requirements, it must be in a position where, by force of logic, it could proceed alone. Hence, in truth, we have 1,071 separate individuals that are not affiliated. They are separate. There's no nexus between them. They have separate claims. They have different bonds with different rights and separate requests for relief. And indeed, moreover, as was explained in the dissent in Abaclat, paragraph 143 for your note, the separate investments in this case involve investments that were made indeed at separate times and therefore have different characteristics. For example, different prices, different dates of purchase, in some instances even after the date of Argentina's default, different places of purchase, different currency, different applicable law. And all of these issues may well bear upon, for example, damages in each case, or indeed the viability of the claim in each case. This characteristic leads to a conclusion which, in my very respectful submission, leads to a characteristic that was missed in Abaclat and in Ambiente and in Alimony. It comes to a particular conclusion, which I'm going to come to in a short while, which I think will bear on Lord Phillips' question as to why, as a matter of analysis, this is so fundamental that it bears upon actual consent rather than just organisation.
Can I just clarify the features that you mentioned in the Abaclat claims? Are they the same here or are they different here?
They are the same here. So there were different series of bonds that were subscribed to in different ways by different parties at different times.
So all three decisions were wrong.
Well, what I'm going to say is that, with great respect, and we all know what that means, the decision in Abaclat and the decision in Ambiente were wrong. The decision in Alimony may turn out to be correct, depending on what happens when the jurisdiction issue is finally ruled upon, together with the merits. But what I will say, also with respect, but this time really sincerely meant, is that the analysis in Alimony is actually the right analysis. This is an issue about not singularity and plurality of investors and investments. It's an issue about dispute. And that is the core focus that distinguishes Alimony from both Abaclat and Ambiente.
This question might be a little premature, but can you give us a forecast of your views on the approach taken by the Alimony Tribunal in aggregating, if I may use that term,
yes,
the jurisdictional question with the merits?
In terms of how they will come out?
No, in terms of that approach.
How it will actually.
Yes,
What
the
will happen
methodology.
The
Yeah.
methodology, in almost all respects, in my respectful submission, was correct, except that the tribunal in Alimony never focused upon the actual criteria that you would use to distinguish a dispute from another dispute. And in particular, what is it that you look at in terms of nexus between claimants and between multiple investments when deciding whether you are faced with one dispute or multiple disputes? So there's not much guidance in Alimony. There are indications in the majority that they may have a more expansive view than I'm going to submit to this tribunal.
I had a slightly different question, which is your opinion about the notion that we should not decide the decision, not make the decision on the consent question today, but regard it as intertwined with the merits.
No, forgive me, I wasn't saying that at all. I'm saying that was the approach that was taken in Alimony. Forgive me if I wasn't clear.
No, I was asking you what your view is of that approach.
That was an approach which, in my respectful submission, was unnecessary in Alimony. And it was an approach that was taken because too broad a view was taken as to the definition of a dispute. And in my respectful submission, it's actually answered by the express language of the BIT itself.
Thank you.
Can I then turn to the next stage in the analysis, which is to apply the Vienna Convention to the offer that is in the BIT? And of course, that is the critical factor in deciding the scope of the Argentine Republic's consent. Two short preliminary points. Again, they don't need to be said. That's never stopped counsel in the history of advocacy from saying it. Consent is fundamental as a cornerstone to arbitration, and all the more so when one's dealing with a state. One has to be careful to find manifest consent, both in terms of existence and scope. Secondly, the mechanism, as is well established in a BIT context for finding consent, is to construe the standing unilateral offer in the BIT and to then see what is capable of being accepted by an investor so as to constitute the operative arbitration agreement. Now, applying the Vienna Convention, the principles are well established, they're uncontroversial. Article 31.1, one looks for interpretation in good faith in accordance with the ordinary meaning of the terms of the treaty in their context and then in the light of its object and purpose. And here that needs to be done in two levels, firstly the BIT and secondly the ICSID Convention. And I say by way of foreshadowing the argument, my focus is the BIT, not the ICSID Convention. Unlike the positions that were taken in the previous decisions, the previous cases, in my respectful submission, the ICSID Convention is actually neutral on this topic. It doesn't really militate either way. And the arguments that have been made on the ICSID Convention by my client in previous cases, I am ready to accept, may well have led into what was described in Alimony as an arid debate on singular versus plural. In my submission, the focus of the point is actually BIT. And let me then turn to the ordinary meaning of the words of the Italy-Argentina BIT. And I think then the tribunal, you will have the text in front of you in about 0.8 font. Which is
We have our glasses.
Yes,
fine.
well, I'm grateful. The key point throughout the text of Article 8 is not, as has been the focus in previous submissions in previous cases, singular versus plural. In my submission, the single determinative thread in terms of interpretation that one finds throughout Article 8 is the notion of a singular dispute. All the way through, one finds a reference to a dispute, never disputes, when read sensibly in context. Article 8.1 to start with. This, of course, is an important provision. It is the chapeau, and it is a gateway in terms of the scope for the rest of the provisions of Article 8, because it's a cascade of provisions one has to go through in order to reach the arbitration consent. Article 8.1, any dispute in relation to the investments between a contracting party and an investor. Any dispute is there quite clearly in the singular. It's not multiple disputes.
An investor is pretty singular.
An investor is pretty singular. And an investor is defined in the definitions section, which I don't have time to go through, in consistently singular terms. But
Counsel, how would you have Article 8.1 rewritten? to achieve the result that you are seeking to avoid?
It doesn't need to be written at all. As I'm going to suggest in my submission, there's no change to the words that needs to be made. The submissions that I'm making are simply on the wording of the treaty as they are, and as will be absolutely patent by the end of this, if they are to encapsulate what I have described as the aggregate, the collectivity of claims, in my submission, you would have to change the words, because you would then have to cater for more than one dispute. And that is really the nub of the submission on interpretation. So now there's a plurality here of investments. Again, I'm not going to spend time, indeed waste the tribunal's time, on an arid debate as to whether that should be singular or plural. It's plural investments.
But pausing there, Mr. Landau, can you help me on this? The word is not just the word dispute, it's any dispute,
Yes.
as if it means that literally any. Therefore,
Yes.
there's a plurality included in these two words, rather than just a single word dispute,
Well,
is there not?
In my submission, there isn't. It is any dispute, and it could have said any disputes.
And you don't think that's an arid distinction?
In my submission, it's not a point that I would myself have majored upon had I not been asked what I say was a fantastically good question. But the focus of my, and I will make this good as I go through this, and forgive me this, of course, this is slightly laborious, it takes some time going through text, but all the way through, and one has to read all this together, all the way through one sees a singularity in terms of dispute. If one then moves on to Article 8.1, just pausing there, in my submission it has to be read in terms of a single dispute, which can be in relation to a single investment or multiple investments, as long as they're made by a single investor. So we've got already a scenario where you can have more than one investment, but the limiting factor is dispute. If one then turns to Article 8.2, 8.2 is absolutely clear, and I'm afraid in the papers, and I will ensure that somebody loses their job because of this, but Article 8.2 has not been reproduced in the text that you have. So forgive me if I will just read Article 8.2. If such consultations do not provide a solution, the dispute may be submitted to a competent administrative or judicial jurisdiction of the contracting party. So there's a requirement for an 18-month period to take the dispute to a competent administrative or judicial jurisdiction. Again, it's a singularity, undeniably, the dispute. Article 8.3. If after 18 months from the notification of commencement of an action before the national courts indicated in the above paragraph 2, the dispute between the contracting party and the investors still continues to exist, it may be subject to international arbitration. And again, in the last sentence, it is any dispute may be subject to arbitration. There is, if I can put it this way, a resounding singularity all the way through. But here, in Article 8.3, we have one further extension. It's not just investor, it is investors. And so one may say, standing back and looking at this reasonably in the round, the parties were relatively relaxed as to investor as opposed to investors, and investment as against investments. But what they were not relaxed about all the way through is the number of disputes. And so one can quite see that one would have different scenarios when you have one dispute, for example, one project, and several investors investing in that project. And that project might be the subject of adverse state action.
Can you tell me how do you define dispute?
I'm going to come to that in one moment. But in fact, it's answered, the actual definition of dispute, in my respectful submission, is answered by the scenarios which are allowed by the wording of Article 8. And there are 3 scenarios that are allowed. Just before I come to them, can I just, in a rush, because time is short, complete the rest of Article 8. If one goes through each of the other subsections of Article 8, you will find a singularity of the dispute all the way through, consistently. If I had the luxury of more time, I would labour and emphasise that as I read it aloud, but I don't. So now can I come back to the President's question? Where does that leave us in terms of what a dispute could be? Under the clear and simple wording of Article 8, there are 3 scenarios that can be a dispute. Firstly, a single investment and a single investor. That's the easy case. Secondly, more than one investment made by a single investor. That's on the express language of Article 8. So you could have one investor that's made several investments in Argentina and then brings a claim saying, I am being unfairly targeted. There's unfair conduct or measures against me as investor. That could be a dispute, even though there is more than one project that the investor is engaged in. And lastly, you could have one investment made by more than one investor, so several people involved in one project. All of that is encapsulated in terms, without any tinkering with the language, in Article 8 language, or on the face of Article 8. But what you don't have there is what is actually being put before this tribunal, which as a matter of analysis is completely different. And that is a collectivity of claimants, investors, and a collectivity of investments that have no nexus. They are not affiliated, they're separate, they have different considerations. And if each one of those could be brought separately to the tribunal, coming back to my Lord Phillips' question at the beginning, why is this so important? Why does it go to consent? It goes to consent because it changes the very fundamental nature of the process. Because if each dispute could be brought separately, my client, the Argentine Republic, would have a right to appoint a tribunal for each dispute. And actually what's happening in this case is not just an enforced consolidation without Argentina's consent, it is the nullification of Argentina's right to appoint its arbitrator for each dispute. And it may be that each dispute actually gives rise to different considerations where a different arbitrator may be perceived as more appropriate. That right has been removed by bringing all of these into one request and calling them a single dispute. Why? Because the nexus between them is the same kind of investment, not the same exactly, and similar activity on the part of Argentina.
Mr. Landau, you have suggested that one of the scenarios is a single investor and multiple investments.
Yes.
Now, it surely is not your contention that those investments can be completely unrelated
Yes.
to, or is it that they can be completely unrelated to one another? If your answer to that is they must bear some relationship to one another, and you'll tell me what your answer is, why couldn't we apply that to the investor as well?
The answer is given again on the text of Article 8. Article 8 envisages a scenario, and I've read it out already in the express language, of one investor and more than one investment. And so the nexus there is the common investor. That's the nexus. And therefore, there is a compromise. Within the text of Article 8, one may assume that the state won't have a right, in that case, to have its own arbitrator appointed for each particular project. The projects could be different. It loses that because of the nexus, the commonality of the investor. And that's not without sense, because in many of these cases, the investor may reasonably turn around and say, you, Argentine Republic, you've targeted me as an investor. I have suffered unfair treatment as an investor, contrary to the guarantees in this BIT. Why? Because project A, B, and C have been discriminated against in the following way, for example.
That is assuming a single issue in relation to a number of different investments.
With respect, no. It could be a multiple of issues, but it's assuming a single target, which is the investor. So there's a nexus.
But is it a single dispute then?
Yes, because of the definition in Article 8. So I'm not applying to this some objective, all-purpose definition of dispute. I'm drawing from Article 8 what it focuses upon, which is throughout, consistently, a singularity, a dispute. And at the same time, Article 8, as I've gone through, admittedly at speed, which I apologise for, Article 8 already tracks, it tells you, it describes the three scenarios, because sometimes it uses singular, sometimes plural. If you read it all together, it's encapsulating each of these scenarios, and it is referring to them as a dispute. All of these scenarios are permitted, and all of them are referred to as a dispute.
Pardon the succession of questions.
Please, very well. Each one of them, I say, has really materially assisted my argument.
Excellent. I'm glad to hear that. You have suggested that the multiplicity of investments, and indeed the diversity of investments, because they could be quite diverse, is not a particular problem in view of the fact that the composition of the tribunal may be the same in all these cases. But is the composition of the tribunal the only consideration here? It seems to me from your papers you were concerned also about the differences and divergences and discrepancies among investors.
Yes.
And my question, obviously, is how do you reconcile your concern over the discrepancies and divergences among investors
Yes.
With your tolerance, unless you
Yes.
inform me otherwise, your high degree of tolerance, so
Yes.
far as I can tell, of diversity between and among the investments?
My tolerance arises out of what is the compromise in the treaty. The treaty itself does not allow my client a free rein to appoint its own arbitrator or to have its own arbitration in every case of multiplicity. That was an argument that was put forward by different counsel, now happily sacked in previous cases, who had majored upon the difference between singular and plural, which was quite rightly described as an arid debate by the Tribunal in Alimony. So that's not my point. There is a mixture of singular and plural. But what one reads from Article 8 is that there are some cases which will be treated as the dispute, and in that is a tolerance. So a dispute will involve, in some cases, like it or not, different investors, as long as there's a nexus. And in some cases, it will involve different investments, as long as there's a nexus. The nexus is set out in Article 8. But it's different, because in this case, we've gone beyond the tolerance that's actually delimited in Article 8.
Right, Mr. Landau, I think your 25 minutes is probably
I'm going to beg, because I've not arrived at my last submission, which I have to make very, very quickly for fear of possible negligence action afterwards if I don't make these points. I'm wondering whether I can borrow, and even if my reply is shorter.
If they are useful to us,
well,
do so.
I'm not going to presuppose that, because that could hurt. But if I can very quickly just come to the final leg of the argument, because all I've done so far is to interpret the words of Article 8. Where I arrive at is, in fact, contrary to the position that's been taken in the previous cases, there is no silence in this case. This is not a case of silence in the treaty that somehow needs to be filled. But where I want to end is by saying, if I'm wrong on that, if this learned tribunal believes that there is silence, or that these words can be read in more than one way, then there are a series of short points, I shall make them very, very short, as to what compelling points as to why you should still come to the same answer as a matter of interpretation. And here they are, there are 4 points. Firstly, and this comes to something we've already debated, I think, and I've already tried to outline, this collectivity, if it's allowed, fundamentally changes the nature of this process. It involves what was described by Mr. Thomas in his separate concurring opinion at Alimony as self-consolidation by one party. So it removes the consent that one would ordinarily have for consolidation or concurrent hearings. It changes the nature of the arbitral inquiry, which will become high level by definition. Dealing with 1,071 claims, it will be a different process from that which was actually contemplated. And lastly, but most critically, it removes, in effect, my client's right to appoint an arbitrator for each dispute. The second point is that if it's put against me that actually, this is the third point. The first point was consolidation and the change in the nature of the process. The second point is the fundamental change in the right to appoint an arbitrator, which is removed. The third point is any argument that's put as to inconvenience or unfairness. If it's said, well, should we expect 1,071 separate arbitrations? Well, that must be broken down into 2 short points. Firstly, insofar as that is an argument about the risk of inconsistent awards or excessive costs, those are problems from my client. They're not a problem for each of the individual claimants. My client is free to agree to consolidate or to have concurrent hearings or to ameliorate those issues. But if my client decides not to and to take the risk of inconsistent awards and the risk of multiple costs, that's my client's right. That analytically doesn't change consent. But secondly, if it is, well, there's no economy of scale, each of these 1,071 bondholders might not otherwise be able to pursue the arbitration. That's a matter of analysis. That's not about consent. That's about funding. And that's about the practical nature of the arbitration, whether it can be made cheaper and more accessible to a very small indirect investor. Again, it's not about consent. Lastly, I think it is right to say that in the grand scheme of this nascent area of law, this tribunal must have one eye at least on the danger of overreaching when construing state consent. And that, of course, will feed into overall objects and purposes of the treaty. May I apologize for going into injury time and thank the tribunal very much. Unless I can give any further assistance, those are the Argentine Republic submissions.
Thank you, Mr. Landau. We will perhaps first hear from Mrs. Donovan, and then you will have a chance of a short reply.
Thank you, Madam President. First of all, Mr. Rossi and the other claimants in this proceeding, as well as no doubt Argentina, appreciate the diligence with which this tribunal has approached these matters, and appreciate the chance to lay out our position here. I also appreciate Mr. Landau's setting the foundation here. He's delivered his points with the wit and elegance with which he is well and indeed justly known. And more than that, in fact, he has, as I read it, significantly narrowed the focus of the pleadings that we've had to date. And of course, the focus and clarity of that argument should allow the tribunal indeed to focus on what are the true issues here. As I proceed, I will try not to linger on points that I understand Argentina now not to be emphasizing, although I may want to set the position, and try to get as quickly as possible to the fundamental point that I now understand Argentina to be making. So first, let's precisely define the issue. What we have here is a straightforward multi-claimant proceeding initiated by a single request for arbitration. The group of individuals, all identified, all represented by the same counsel, all pursuing the same claims, or at least similar claims, arising from the same investment or a similar investment. It's not a class action led by a representative. There are no representation issues. It's a straightforward multi-claimant proceeding. I will elaborate in a bit. One other preliminary point, which I don't think Argentina takes issue with, but I want to be clear, and that is, I think we're agreed that the interpretive task for this tribunal is governed by the Vienna Convention on the Law of Treaties, and that there is no rationale here, no reason to put the thumb on the scale in favor of jurisdiction or against jurisdiction, in favor of consent or against consent. What this tribunal is trying to determine, based on the treaty text, is whether there is indeed consent. And I think we're in agreement on that, but it's an important point.
I think so. Can you just clarify, the interpretation that we're going to place on the BIT, is it going to be interpreted as at the time when they entered into the treaty, or now?
Well, I'm not so sure. I'm not sure that Argentina has made me point of difference with respect to that. And I think the plain text of the treaty, there are no indications that people are interpreting it differently. So in either case, as I say, I don't think Argentina has made a point that there is any text available to the tribunal based on the Vienna Convention that might affect the interpretation.
I see. So the timing doesn't matter.
As far as Argentina's put its case, certainly not. I mean, we're perfectly prepared to rely on the text as in its ordinary meaning. And I want to do that in two steps. I will go quickly through Article 25, because again, as I understand it, Argentina does not really contest that Article 25 would not permit the kind of proceeding that we're focused on. And I think that's the appropriate position, especially given the wide latitude given to qualifying parties to agree to exit arbitration, explored most fulsomely in the context of the definition of investment and the criteria of nationality. There would simply be no basis to conclude that the drafters intended to exclude, as I say, qualifying parties to agree to multi-claimant proceedings. To put it in terms of the Alimony Tribunal, there's simply no reason to insert the phrase, but only one, into the jurisdictional text. But I take it that Argentina does not really take issue with that point, so I will skip over some other points in favor of that presumption. So where I really want to go is the text of Article 8 of the BIT, because that's where we engage issue here. This is where we have our dispute. Our suggestion is that if you look at the plain text of Article 8, it plainly contemplates multi-claimant proceedings. It starts, Article 1 refers to any dispute, as broad a term as you can have, in relation to the investments, multiple, between a contracting party and an investor of the other contracting party, in relation to the issues governed by this agreement. Now, for purposes of this argument, the tribunal must assume that each of the investors qualifies as an investor. And it must assume that the bonds qualify as an investment. And it must assume further that claimants have stated a sufficient case in the traditional manner, that is with respect to the breach of the treaty obligations, for purpose of prima facie jurisdiction, because that's the premise of this argument with respect to consent. Even so, however, Argentina argues, the tribunal's jurisdiction fails because the claimants have brought their individual claims in one single request for arbitration, and the BIT doesn't permit that manner of proceeding. And as it is emphasized and clarified here, because it doesn't, these claimants do not partake of the same dispute. So one question we might ask, which we now have an answer to, is where does that limitation or prohibition arise? My respectful submission is, despite the parsing of that text that counsel has just gone through, you can't find it in the BIT and in the ordinary language of the BIT, and in particular the Article 8. And my respectful submission further is that engages the argument we have just heard, falls into the trap of lexicographical literalism against which the Alimony Tribunal warned. First of all, I appreciate the recognition that if there were a dispute with respect to multiple investors or multiple investments, that would itself not be precluded. Argentina's position here is very precise. We can have multiple claimants in certain circumstances. We can have multiple investments involved in certain circumstances. We can have multiple investors and the like. The narrowness of the position is simply that this must result from one dispute. And we appreciate that acknowledgement because Article 8, of course, expressly contemplates, as Argentina now recognizes, certainly the prospect of multiple claimants. Article 8.3, as previous tribunals have emphasized, expressly refer to, quote, the dispute between the contracting state and the investors in the plural. That's not a drafting accident. It's in the plural in both the Spanish and Italian authentic texts. The heading of Article 8 also refers to investors. Of course, we have here, as other tribunals have pointed out, an investment which by its own nature contemplates widespread participation, that is in bonds, but you don't need to go to that consideration in order to reach the point that obviously the Article 8 contemplates multi-claimant proceedings. Now, very briefly with respect to Abaclat and Ambienti, both of them recognize that. Both the Abaclat Tribunal, which was criticized, of course, by Ambienti because its reasoning was, in the Ambienti Tribunal's view, too thin. My respectful submission is that it found the question obvious. It did indeed look to Article 25 and note that there was a legal dispute. The parties conceded that there was a legal dispute in the sense of Article 25. And it also found the answer it came to by examining Articles 1 and 8 of the BIT in connection with Article 25. It simply found no reason in the text of the treaty to find that a multi-claimant proceeding would somehow defeat jurisdiction, as Argentina now argues. Ambienti, likewise, looked at the plain consequences of Article 8. In the core of its reading, although it listed several other considerations, it looked first at Article 25 and noted that nothing would force the tribunal to conclude that the wording of that article, and specifically its reference to a national, could not also encompass a plurality of individuals. And again, it made the same point with respect to Article 8.
Mr. Donovan, excuse me. As I recall the Abaclat award, there was mention of the fact that the issue before us should be regarded as an issue of admissibility as opposed to an issue of jurisdiction. Is that a distinction that makes any difference to us here?
Well, if there is a concern, and with the tribunal's permission, I would like to give a brief answer now and then return to this very point. Because if there is a concern along the lines that Argentina has now outlined, that is, that it's too many disputes, that what I take it as some kind of manageability concern, if there were that kind of concern, it would go to admissibility. I would not concede that, particularly given our our contemporary emphasis on efficiency, on the high competence of tribunals, on the availability of technology and the assistance of dispute resolution, that you would ever get to a point where it would actually deal with admissibility. I would suggest that an effective tribunal could indeed respect the right of both parties to be heard, and that we wouldn't get to that. But if there were such a concern, yes, it would be a matter of admissibility, not jurisdiction.
Do you concede that there is an issue of jurisdiction in this case, or is it entirely admissibility?
No, I think there is jurisdiction. And as I say, I think the issue we're talking about now is jurisdiction.
Thank you.
And if you were going to go to admissibility, it would be a different question. I myself don't see a question of admissibility here. But if you were going to take account of some of the concerns that previous tribunals have addressed, it would really go to concerns as to whether or not, notwithstanding jurisdiction, the claims were admissible because the tribunals simply were incapable of respecting the individual rights of the parties. So let me go to the question here of dispute. Because as I understand, Argentina is now picking up on the Alimony Tribunal's emphasis, or at least, again, as the tribunal will appreciate, one of the arbitrators in that dispute, in that case, did not agree with the reasoning, the full amount of the reasoning of the full tribunal. But the Argentina has now picked up the notion of a dispute, and I think largely builds on that tribunal's reasoning. What we now have, in effect, both on the part of Argentina and from the Alimony Tribunal, is the identification of a heretofore unknown jurisdictional requirement to either Article 25 or indeed Article 8. And I would respectfully suggest that there's no way that you can find that. What it is clear from the Alimony Tribunal's position that it found that jurisdictional requirement in Article 25 and then carried it through Article 8. As I understand Argentina here today, it does not reiterate that point on behalf of Article 25, but it does take the position with respect to Article 8 by the means of the various scenarios we've just heard. But the question there would be, why would we take the various scenarios that Argentina has laid out with respect to Article 8 and view those as exclusive? Why would we take the terms in each case, why would we take a term like a dispute, any dispute, and treat it as not encompassing the plural? The tribunals, I think, are reasonably consistent in saying that surely the interpretive exercise under the Vienna Convention on the Law of Treaties is not dictated by the reference to an investor or multiple investors. And of course, Article 8 is strewn with the use of both the singular and the plural. So
it's another question here, really, of what is meant by dispute. Mr. Landau is at pains to emphasize the possibility of different issues. If you have a common issue and a number of investors, is that not plainly a single dispute? And conversely, if you have a number of investors with raising different issues, then you haven't got a single dispute.
Well, with the greatest respect, I would not rest simply on the point about singular versus plural. I would take that as, first of all, I think you can read the language not in Article 8, just as you could read the language in Article 25 to refer to disputes multiple. I don't think, but on the same rationale that the tribunals, and most adamantly the Alimony Tribunal, have read that with respect to investor investment, I think the language can easily encompass the notion that there would be more than one dispute. But let me go directly to your point. Here's the question about how one defines a dispute has arisen in these cases, although has become most specifically addressed by the Alimony Tribunal. As you'll recall, there was discussion in Ambianti about whether or not there's a significant and important link. Here's my basic proposition in response to Alimony Tribunal's reasoning, which I think underlines the Tribunal's question. The Tribunal in Alimony put its task in the context of the various instruments here as follows. It said, until the Tribunal has been put in a position to do this, that is, determine what the claimant's rights and expectations were, and whether or how far each of the claimants had been deprived of them. This is the Tribunal's reasoning. The Tribunal is unable to determine with the force that a formal preliminary decision requires whether the actual, the Tribunal's emphasis, rights of all the claimants, paren, I know this takes a while, but this is the Tribunal's reasoning, and I think it's very important to focus on it. Paren, under Argentine law, and such rules of international laws may be applicable, close paren, and whether the actual, again, the Tribunal's emphasis, effect under Argentine law and such rules of international laws may be applicable on those rights or associated expectations, and this is a reference, of course, to the expropriation and fair and equitable treatment claims, of Argentina's conduct were sufficiently the same as to amount to a single, quote, dispute over Argentina's obligations under the bid, even within the broad and non-technical understanding of a, quote, dispute that is appropriate to Article 8 of the bid, read in conjunction with Article 25 of the Convention. Now, forgive me that long quote.
That sounds to me as though it's a question of whether there's a sufficient communality of the issue.
Well, that is one way to think of it. The Alimony Tribunal itself suggested that that was indeed a complicated statement of the jurisdictional inquiry, and yet that is what Argentina invites us to undertake. And I recognize, just because it's complicated doesn't mean it's wrong. But let's examine it for a moment. First of all, of course, as I say, that the suggestion, the Argentina's position here, following on the Alimony Tribunal, gives talismanic significance to singular and plural in a way that it would be otherwise just completely eschews. But let's go directly to that inquiry that the tribunal has in mind. It is well established, universally recognized as a matter of international law and international dispute resolution, that in fact, when one looks at jurisdiction, one takes allegations as a matter of a prima facie case. If we are, in fact, in the guise of determining whether there was a single dispute, if this tribunal had to put itself in the position of determining the very character of the different claimants' rights under different bonds, and again, as the Alimony Tribunal suggested, and as Argentina asked you, as I understand it, to take it, the actual effect of the measures on those rights, as a matter of its jurisdiction, hasn't it gone right down the path beyond what jurisdiction might be? That can't be right. In this case, in all of these bond cases, all the claimants allege that they have a similar economic interest in an asset that qualifies as an investment and have been affected in essentially the same way by essentially the same measure or measures. There is neither need nor basis to ask more to precisely identify the dispute. This is a dispute. And we can examine that proposition by asking the task that the tribunal has set for itself.
Mr. Donovan, may I assume I read you or I hear you as proposing alternative ways of understanding Article 8. Are you suggesting, first of all, that any dispute should be understood to be plural or multiple, to accommodate multiple claimants? And is it also your claim that we can have a single dispute arising out of multiple transactions? Are you making both arguments?
Exactly so.
I wasn't clear, because most of your argumentation up to this point relied upon our treating any dispute as indicating multiple claimants, whereas perhaps what you're saying now is that we could have a single dispute. You could live with a single dispute. You could live with any dispute, meaning a single dispute, if we define dispute broadly enough to encompass multiple transactions.
At the risk of shamelessly echoing the tribunal, I think the search for a singular or plural interpretation leads nowhere. But even if one accepts that that's what we have to do, given the circumstances here, it is very easy to conclude that there is a dispute. There are sufficiently close characteristics here. I wouldn't admit that one has to find a single dispute, but there certainly are sufficient characteristics to find one here. And the way to look at that, another way to look at that, is to say, what is the Alimony Tribunal going to do, and what is this tribunal asked to do? Is it really going to investigate all of the characteristics of each of these bond instruments, when they were purchased, what their economic characteristics are, what the claimant's rights are under them, and then examine, as the Alimony Tribunal suggested, the actual effect of the states of Argentina's actions on those rights and expectations in order to determine jurisdiction? It's going to get to that point and then determine whether there's sufficient commonality to determine jurisdiction. I'd respectfully suggest that that is not a fair reading of what either text contemplated, and with the greatest respect, it just doesn't make much sense. Could I have a time? Ooh, okay, if I may, in addition, just take 2 minutes. I'll take much less than my colleague, Mr. Landau.
I have no doubt.
So, again, I would go, and this, again, responds to Argentina's suggestion of what it's really being deprived of here. I mean, what's the suggestion? If we don't have jurisdiction here, if the tribunal doesn't have jurisdiction, what Argentina is suggesting is that these claimants should be filing 1,071 separate requests for arbitration. Appointing separate arbitrators? Well, not really, because of course, presumably, each of those claimants could appoint the same arbitrator. Argentina has indicated it's going to appoint 1,000 arbitrators. If it does so, what purpose is that serve? Can ICSID, assuming that the parties don't agree, can ICSID appoint a single president? If, in the interest of efficiency and avoiding inconsistent results, which is something that we are all looking to do in the modern era of international dispute resolution, might a tribunal consolidate its proceedings? Could it not formally consolidate, but coordinate proceedings? Could it hear similar witnesses? Many of these issues, even on Argentina's, of course, would be common to all of these proceedings. And this is all, as we have heard it in the service, we've heard this close parsing of the treaty text. But the substantive interest protected, as we have heard it this afternoon, by this parsing of the text and the requirement of single dispute, is Argentina's right to appoint a separate arbitrator in 1,071 cases. It's not being deprived of its right to appoint an arbitrator. Let's be clear, because if this tribunal goes forward, as of course Argentina already has appointed an arbitrator, and it will be able to appoint an arbitrator to hear these claims going forward. The substantive interest that Argentina sets up against the text of Article 8 that the states parties apparently had in mind is Argentina's right to appoint 1,071 arbitrators. Our suggestion is that that is not what this text contemplates, and that the text of both Article 25 and Article 8 easily encompass this dispute involving these claimants. I will stop here, and I'm sure the tribunal will have questions. Happy to answer any further quick questions that might assist the tribunal.
Well, we'll do that after Mr. Landau has a reply.
Well, thank you very much, and I'm very grateful to my own friend for his submissions, which I think have clarified a number of issues. They've been done with great eloquence, and in some respects, I think have narrowed the issue even further, because a lot of the target of my own friend is indeed a case that we're simply not making, and I'm going to explain that. A number of points, separate discrete points by way of reply. Firstly, a question was put to my own friend as to the time at which the interpretive exercise is to be conducted under the Vienna Convention. It is our submission, as set out very clearly in the dissent in the Advocacy case by arbitrator Avisab, that the time is at the point at which the treaty was concluded. And that is significant, because under the Vienna Convention you are mandated to look at the context. And the context of the treaty, the context of the words, was a time in history where mass claims were not recognized in the way that they are now.
Is the implication of what you're saying that there is no term in these instruments that can have a dynamic meaning that changes over time? Are we frozen in the understanding of the drafters at the moment, or should we not be somewhat more teleological about this? And what result would that lead to?
By all means, be teleological. I'm never one to stop anybody who has a tendency towards teleology. But the scope within which that exercise is to be conducted is aptly described, if I may say, by arbitrator Avisab in his dissent as the horizon of foreseeability. The horizon of foreseeability puts limits on that process, so that, of course, there will be some dynamic element. But you cannot, in my respectful submission, come to a construction of what was agreed at the time if it can be quite plainly shown that it could never have been foreseen. It was simply beyond reasonable contemplation. So that's the first point.
But just to follow on from this question, and in your submissions earlier, you pointed out that there were 3 ways in which one is to look at disputes, by the link between multiple investors, the last of which is multiple investors and a single investment.
Yes.
Is this not exactly one such a situation?
No,
Why not?
because you have got separate investors with
Yes.
no affiliation with each other who have made separate investments that have no connection. They're governed by different law, they were taken out at different times, under different circumstances, there are different ways of holding the bond, there are secondary rights. So this is not what is quite clear on the face of the language of BIT. It's not one investor or a collectivity of investors that are closely affiliated so as to be in substance one investor. And it's not one investment or multiple investments that are connected through one investor so as in substance to be one investment.
If you have one bond issue,
Yes.
subject to its terms,
Yes.
and 100 investors each buy one
Yes.
bond,
Yes.
and there's a single issue of interpretation of what the bond
Yes.
is promising, is that one dispute or more?
It's more.
That is still more.
Yes, because in each case you would have to pass the test of through the BIT of establishing that you have one investor who has an investment, and each of those investments is that investor's investment. It's not anybody else's investment.
Can we not understand the whole structure of the sovereign bond being the investment and the different law and the different timing being specificities that relate to perhaps how the damages is to be calculated rather than a separate dispute?
In my respectful submission, one can't do that because a bond can't be treated as a single project such as a power plant. It's not one investment. It is a financial instrument. And the way that it's crafted, of course, one stretches the concept of investment in order to include these economic rights in BITs.
I see.
But one doesn't lose the whole notion of one investor making its own contribution in a particular way in the host state. The fact that all bonds, it is a bond issue which more than one person can participate in, doesn't mean that everybody actually is doing the same thing, in my respectful submission, as participating in one power plant. They're not. They are all investing in different ways in an economic right that's being made available to them, but they may take it up in different ways. And so the nexus there is just not the same.
I don't understand. If you've got a single bond issue on identical terms, how you, and each individual investor buys one bond, how can you say they're investing in different ways?
Because you have to look under the BIT, you are told under the BIT to isolate each individual investment for an investor. It is an investor who makes an investment. And there's no coordination there, such as clubbing together to build a power project. It's chalk and cheese. And at that point, once imposing onto a financial instrument the idea of a singular I'm in a state of some alarm, I have to say, because any arbitrator who tells me that they don't understand could have an adverse impact on my billing. And so I'm hoping that I've made the point clear, although I've done it with some speed, that the two can't be equated. Can I very quickly, asking the indulgence of the tribunal, just touch on what is perhaps the core issue I need to respond to? The core issue I need to respond to is the argument that's put against me that isn't my argument. The argument is that the Alimony Tribunal got it wrong in the way that they define dispute. The argument is that the Alimony Tribunal has set out a loose criteria that would embroil this tribunal in actually determining the nature of each claim, the circumstances of each measure, and its potential impact on each claimant's investment. And that is exactly what we're saying is not the right test. The test is not what Alimony said. The test is simply the criteria on the face of Article 8. It is the scenarios that are set out and delimited in Article 8. And so everything that's critically said in a critical way about Alimony, we would respectfully adopt. And that is why we say that for precisely those reasons, Alimony is wrong, and actually a dispute here is defined by Article 8, and that requires none of this loose kind of inquiry. Again, with apologies for now having exceeded my time on both occasions that I've addressed you. Unless I can move any further assistance, those are the short points.
I think you still have about 2 minutes.
Have I missed time? In that case, let me make 2 other points. My second of the extra additional points is as follows. Can I note for the record the concession that has been made by the claimants that this issue is not one of admissibility? It is an issue that goes to jurisdiction. Now, that is a significant concession, because it answers my Lord Phillips' question that was put to me at the outset. Isn't this just organisational? and no, it's not. It seems common ground is jurisdictional. Why is it jurisdictional? Because it goes to the root of the process that has been contracted for. And here this takes me to the second point. The second point is it cannot be said against me that there would be no utility in the Argentine Republic seeking to appoint a different arbitrator in each dispute. Of course, that is the right of an arbitrating party. It may have any of its own private reasons to want to have its own representative of choice on a panel, even if the claimants appoint the same arbitrator in each case, even if the same president appears in each case. That cannot negate what is a fundamental right. And that right is not just something which as a party would like, it goes to the very raison d'etre of arbitration, which is to have a tribunal of your choice, unlike a standing court. And that is why this point is jurisdictional, and that is why it is important to see Article 8 as a compromise which is delimited by way of this notion of dispute.
May I prolong the delay?
I'm happy. I'm happy if that happens.
Yeah. I guess my question would be, is it the case that Argentina would be prejudiced by having a single tribunal? Are you suggesting to us that it would be in your client's interest to have a separately constituted tribunal
with
for
respect,
each claimant?
Yeah, with respect, I don't need to. I will answer your question in a minute, but I don't need to prove that they actually will be prejudiced. All that I need to show is that they have what I would regard as a fundamental, inalienable right of choice. Now, if they can exercise their choice the way they want, they don't have to show why they're exercising it in a particular way. And if they have that as a fundamental structural aspect of this process for which they've consented, then the loss of that itself, without more, is prejudice sufficient to go to jurisdiction.
Well, the premise of that, I think, is that argument rests on the premise that we have multiple disputes.
Yes.
Here. So that is fundamental.
Well, the premise is that we are in a territory that is beyond Article 8. And Article 8 has in it already the notion of, as I've said, multiplicity. But we are one step removed from that.
Thank you.
Thank you. Thank you very much, Mr. Landau.
Just 4 quick points, if I may. First, with respect to timing, we recognize Professor Abisab's resort to the horizon of foreseeability, but I would stand on our initial submissions. There is material, of course, that each of the previous tribunals have relied on to suggest that even under Italian and Argentine law at the time, there was some contemplation of multi-claim or multi-party proceedings. There was a discussion amongst the Tribunal. My basic point is that one need not even rely on the notion of dynamic interpretation. It is plain on the face of Article 8 that this kind of multi-claimant proceeding is contemplated. Secondly, I appreciate the purity of Argentina's argument and the clarification that I have perhaps mischaracterized Argentina's argument by assimilating it to that with respect to the Alimony Tribunal's analysis. But I think that cuts precisely the opposite way, because the suggestion here that notwithstanding what we all agree would be too literal an interpretation to suggest any and a interpretation, that we need to slice this controversy into individual disputes depending with respect to each bond itself, I believe, illustrates why that would simply be an impractical and more importantly, in the context of the Vienna Convention on the Law of Treaties, not taking account of context, taking account of object and purpose. With respect to the jurisdictional question, we are arguing, of course, jurisdiction, and if I have not spoken precisely, I appreciate Mr. Landau's point of clarification. We believe we have jurisdiction. I believe you could, if you found jurisdiction, it is possible that you could take account of this as a notion of admissibility. My basic point is I don't think that either jurisdiction or admissibility should prevent this tribunal from going forward with respect to all these claims. The answer is in proper administration of the proceedings, proper sequencing and classification of issues, the standard efficient techniques.
But this is exactly what I think Mr. Landau is saying. If it's admissibility, you might be able to consider those matters, but since it is a pure jurisdictional question, all that he is relying on at the moment is, well, I shouldn't say at the moment, I think he relied on a number of things, but his last comment was his right to appoint 1,070 arbitrators.
No, I appreciate Argentina's position is that this should not be subsumed into admissibility. My suggestion is that I can see an argument. We believe that there is clear jurisdiction. I can see an argument, as was raised, that this should be counted as amongst admissibility. What I said is I don't think there should be any admissibility objection based on this, on basic. To me, this is a matter of procedure and case management. And that, again, goes exactly to the final point. We've heard in Argentina's reply that this, again, comes down to its ability to appoint 1,071 arbitrators. And my respectful submission is that there's no way to read Article 8, notwithstanding the extraordinary skill of Mr. Landau, to find in that a right to appoint 1,071 arbitrators. There is surely a right to appoint an arbitrator, but that right is fully satisfied by this tribunal sitting right here, and this tribunal going forward with these 1,071 claimants and hearing Argentina fully and hearing my clients fully and adopting such procedures that may be efficient but fully respect the parties' respective rights to be heard. And one final point, and that is we agree that consent is required, that consent is fundamental. But this tribunal should not lose sight of the fact that it is administering a justice system, that it is dispensing justice. That does not put a thumb on the scale of whether or not there has been consent or hasn't been consent, or whether there's jurisdiction or not. But the Vienna Convention on the Law of Treaty, though it does not mention common sense expressly, doesn't preclude it. And my suggestion is if you read Article 25 and Article 8 and compare the proceedings that Argentina apparently contemplates, that would surely burden and possibly frustrate the claimant's ability here to have their claims heard in what, after all, is going to be a full and impartial, fulsome proceeding before an impartial and independent tribunal in which Argentina will be able to be fully heard, that would not be consistent with a sensible interpretation, with the ordinary meaning in context and in light of the action and purpose of the Vienna Convention in interpreting these treaty texts. I appreciate the tribunal's patience.
Can I just follow up on a question, Mr. Donovan? I understand how you say that this is a multi-party claim because it relates to a sovereign bond, and Mr. Landau is saying because of the different laws and all that, it doesn't matter. You would say it doesn't matter. They're still in one proceeding within the dispute. Can I just test that proposition? If, let us say, Argentina say that there are going to be a number of power plants exactly the same to be constructed by foreign investors, Italian investors, at various places in Argentina, and somehow there are disputes in each of these projects, would you say they can still be brought by way of a multi-party proceedings before one tribunal? Because they would be different investors and different, well, maybe even, it can be different investors in the same investment, building different parts of the power plant, or alternatively, one investor building a number of identical power plants?
My submission would be yes, those claimants could bring those claims together, and the tribunal would organize those proceedings in the fashion that it found appropriate. But there's nothing in the text of Article 8 or Article 25 that would preclude those claimants bringing those claims in a single request for arbitration.
And how does one find that nexus then for that to happen? Because it's identical power plants, and therefore...
Well, they're identical power plants, and as I understand the hypothetical, there's a similar measure brought to a similar measure that harms them. As I understand Argentina's position, for example, it does not contest that a claim brought by the same investor with respect to different investments affected by different measures would be contemplated by Article 8. And what we don't see is how one can parse Article 8 in the fashion that Argentina has suggested, but then stop and say, in this case, because these claimants all bought bonds at different times, that's a different dispute, and that can't go forward. That parsing just finds no basis in Article 8.
Yes. All right, then. Thank you very much. Thank you. I think we've had the submissions of the parties. Thank you very much. We will, of course, have to reserve our decision, so we will now deliberate.
Well, I was looking at the dissent of Santiago Bernardes in Ambiente, and this statement: I am obliged to call to attention the fact that in public international law, logic is never a source of jurisdiction for international arbitral tribunals. And that struck me as Mr. Landau's thesis. Or at least.
Okay, the advocate's comment?
I'm not sure if I'm allowed to interrupt or not, but if I had enough time, I was going to quote that. That was in my notes.
I think what we can do perhaps is that we will have a quick discussions, and we will then ask the advocates to comment, and somebody will be watching the time for us, right? Okay.
I noticed that neither of you addressed the distinction between what is good policy and what is the proper reading of these texts. And I trust you feel very strongly about that proposition, that what is desirable, policy-wise, is not determinative of how we read these texts. Now, is that your view?
No, actually, if I'd had more time, I would have gone through much more policy. That was the last part when I was out of time. I would have gone through more of the policy reasons.
And you would have invoked policy in favor of your position. Yeah. Would you do that?
What I actually think.
Yeah, would you do that in 10 seconds? Would you tell us what the policy argument in favor of your position?
Yeah, actually, I do.
I think I could predict your policy argument.
For what it's worth, the actual policy I think that is really significant here is the one that I was labouring, and there are many other aspects to it. If you imagine the situation post-dispute, after a request has been served, it's uncontroversial that you can't impose consolidation on a party, and you couldn't stop a party from choosing their arbitrator, and you can do many things that in fact are being done by joining together beforehand. So the issue for me actually is a real issue. That actually what is being achieved by this collectivity is to change the nature of the process and reduce the options that otherwise would be available.
I think the flaw in my question was the vagueness of the term policy. Is it legitimate to take into considerations of efficacy?
Right.
That's really what I meant to say.
I see. Then of course, it's all channeled through Vienna Convention. So in Vienna Convention, I think a lot of that would come up in objects and purposes, which is, I think, what Donald was making the point also, that some of the very unfortunate consequences of my argument in terms of practicality is picked up, obviously, by Donald in terms of saying, well, that can't be the object and purpose.
And I think that's the great difficulty in this radically horizontal justice system with ad hoc tribunals. I think arbitrators need to be disciplined about policy. You're not legitimated by anything other than that single dispute, and that, of course, is how far can you take context and, in particular, object and purpose. And we've all seen reasoning that seems to, at least in my humble view, seem to be extremely aggressive in the service of object and purpose. But I don't think, and I tried to strike this balance by saying, look, I'm not questioning consent. I'm not suggesting that you don't need to find consent. But it does seem to me that you can take a look at the practical. It is even either as in informing one's decision or as checking one's decision. And I do think that the consequences of what Argentina's position here, and I will not attribute it to Toby because he was an advocate, the consequences of Argentina's position really does seem not to serve the basic purposes of a dispute resolution mechanism. And as I said, I do think the fact that I don't see the fundamental right to be able to appoint an arbitrator in a bunch of different cases. It's to appoint an arbitrator.
Can I make an advocacy point on this? I'm sorry to interrupt because you may want to deliberate. But if only every arbitration was like this, would be fantastic. As a matter of advocacy, in answer to your question also, my own feeling is that the degree to which you emphasize policy depends on your arbitrators. And there are arbitrators who one might think might be attracted to an answer that's served up in black and white.
Have you typecast us?
No, I'm treading carefully at the moment.
Well, I'm a policy manager.
I think that's right. I think you always, even in commercial cases, you always make the policy argument. You always say the rule I'm arguing for leads to sensible and productive business conduct. And in this case, the rule you're arguing for leads to a sensible universal dispute resolution. So you always make the quote-unquote policy argument.
And I think you have
It's
a
always-
very solid basis in the Vienna Convention
It's the,
for doing that.
yeah, it's always, I think, the last argument, and as so we said, it depends on who your arbitrators are as to the emphasis, but I think you're always trying to say, look, I'm arguing for a sensible rule.
Could I ask you a question? The same question I asked Mr. Landau. What would be your reaction to the notion that we follow essentially what the Alimony Tribunal did and just punt for the moment on this question and regard it as so merits implicated as to simply not render it a judgment on that point at this stage?
Well, I've already said hello to Frank, and he said he may not be able to stay. So I will repeat what I think both Toby and I were a little bit time pressed. These are interesting issues. I just find that difficult, and particularly in light of what we all accept as for purposes. It may not be strictly speaking the same issue with respect to the claims. You don't have to prove your fair and equitable treatment. You just have to state a case. You don't have to prove expropriation. But the notion that the tribunal, the task that Alimony has set itself, if you read the paragraph I quoted, which is it's going to determine the actual rights and expectations and the actual effect of the measures on, the notion that you would go through that exercise and then say, oh, no jurisdiction, you'll go out and file your own request for arbitration, that just strikes me as not a sensible way to proceed. What strikes me as the sensible way to proceed is you're doing that, you're organizing the proceeding, what kind of groups do we have? You're not in any way, there has to be individual decision making with respect to each claim and each claimant. But it does seem to me you can organize the proceedings to get to efficiencies and determine, do we have, God forbid I suggested subclasses, different categories of people so that you render efficient proceedings. But to go that far down the pike and then dismiss on jurisdictional grounds, just it would be interesting. Of course, if they are publicly available, I confess didn't look for them, but it would be interesting to see what the procedural orders do in that case.
To follow up on my question, and I appreciate your answer, Donald. I've been struggling with the Alimony award myself because, as I mentioned to Teresa earlier, it seems to me not all jurisdictional issues are alike. And tell me your thought on this. Is this a jurisdictional issue, if it is one, that we can effectively postpone? I have worried a little bit about the character of this jurisdictional issue. The notion of postponing it presupposes that we have settled on some architectural features of the arbitration. Am I correct about that? And does that make it, I'm sorry he's left, but does that make it,
couldn't say anything anyhow, so.
But does it make it difficult to decide how to proceed without having made this jurisdictional determination, considering it's an architectural question?
Well, one interesting point, of course, is that both Toby and I neither endorsed, and Toby made it crystal clear to the extent that I was suggesting otherwise. Both of us, in effect, said, decide it now, right? And Toby's position is, of course, that the features are sufficiently clear that you can decide that there's no single dispute. And my view was, look, the features are sufficiently clear that you can determine that you have jurisdiction, and whatever else you do in terms of organizing the proceeding is up to you. My view is that, certainly is the advocacy view, is that this is effectively what the consent here, and I think this does make it a challenging argument, is not about is about the manner in which you will proceed, and that immediately partakes of procedure. And I suppose I'm not prepared to say that it would never be the case that might not affect consent, but it does seem to me that it ups the ante a bit to read in the consent instrument that there's only a certain way of proceeding. And that is at least a distinction. Is it a dispositive difference? Is it dispositive as for these purposes, or does it just make it a bit more challenging?
So I like all the ruling is.
The ruling is that time is up.
Indeed.
I think we've just had a prompter from Federico that I think we've finished our deliberation. We will still continue to reserve. Federico, you going to say something?
Just very briefly, and in fact, before we move to the reception, I hope you were able to appreciate, at least I was, the complexity and I think also the idea behind this event today, which will make it an annual event, is that the advocacy is crucial, right? And our two advocates were brilliant at that. And at the same time, I leave the room thinking both of them are right and both of them are wrong. And there's really no right answer. And so it's really a nice combination of, and for that, I ask you to give a round of applause to the two advocates and the tribunals. And thank you.